Any mention?
May please, Your Lordship. Your Lordship, I beg to make a mention of item number 8, Your Lordship. I humbly pray, Your Lordship, kindly this matter may be listed after 2 weeks, Your Lordship.
Have you
Yes, Your Lordship.
received consider
JJDC, Your Lordship.
on premier by petitioner? List this matter up to 2 weeks.
Highly obliged, Your Lordship.
And please, Your Lordship. Lordship, beg to mention item number 9, madam. I've been from the item number 9. I've been from the other side. Matter may kindly be taken up after 2 weeks, madam.
Objections.
To 9 2 weeks.
Much obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 11.
11.
My lord, in the item number 11, on the 9th of December 2025, my lord, the former Chief Justice has passed an order. I'll just read out to my lords. I have heard the learned counsel for the parties. The matter is adjourned till 28/01/2026 in order to enable the learned counsel for the petitioner to take necessary instructions, my lord. And what was that instructions, my lord? The instruction was how much money she can pay to the respondent, my lord. Because
No, my lord. I object, my lord.
No, let me. Because the issue was, my lord, the issue was that the petitioner herein has taken money for investing or for buying a property, my lord, and there is on the record also, my lord, there's a money transaction that has happened, my lord. So therefore, in the course of the hearing, my lord, the lordship was of the view that if you have taken the money, then you are entitled to give it back. So therefore, my lord, and even this went to the log adalat, to the mediation also, my lord. Mediation, we have given some proposal also, my lord. Without interest also, we have given a proposal, my lord. That also is on the record, my lord. So on the basis of all collective basis, it was given the instruction, my lord. Instruction, just that much. It's very simple case, my lord. Just take instruction how much you are paying. You cannot take somebody's money, enjoy, and later on you come on technicalities of the law, my lord. That was of the
My
view.
lord, my
my lord.
humble
matter-
submission, my
no,
only
this-
instruction.
This matter has gone for mediation.
Yes, it has gone for a
Not
mediation.
settled.
No, it
Not
was not
settled,
settled,
my
my lord.
lord. It was
We
not
gave him
settled.
3 proposals.
My lord, for that I have my submission, my lord. I have seek an instruction, and particularly, my lord, the petitioner has stated to me that it was the money which was returned by the respondent to her, because they had obtained a loan from her husband and her mother as well, my lord.
We'll not go.
And
We'll not go into.
That's nothing.
But my
nothing on
lord,
record.
If you
so
want,
my lord, at
if
this
you want to argue on merits,
Yes.
we'll argue on merits, my lord. Kindly give me some time. That's my only prayer, my lord.
Otherwise, my lord, what is happening here, my lord? Because of the pendency of this case, my suit in the district council has been pending since long, my lord. We cannot proceed to the suit, my lord.
My
So
lord,
it's
this
getting just linger around, my lord. That's the thing, my lord. Otherwise, let it go back. Let it go back. Let the trial start there.
My
Simple
lord-
as that. If whatever they're saying that the money was actually returned back, that will come out.
2 weeks.
2 weeks, my lord.
Premier by petitioner, 2 weeks.
My lord.
highly obliged, my lord.
May it please your lordship, I beg to mention item number 7. Can you have this matter to
Come after 3 weeks, then your lordship. If adjournment is sought, 3 weeks, then.
3 weeks.
Apply, your lordship.
similar brief for item number 3, your lordship? I'm appealing on behalf of respondents 3 and 4.
No objection, Lordship. No objection, Lordship.
On premier by respondent 3 and 4. And counsel for petitioner. Not objected to by petitioner. This is matter up to 2 weeks.
Highly obliged, your lordship.
Your Lordship, I beg to mention item number 10, Your Lordship. Your Lordship, kindly let this matter be taken up after 2 weeks, Your Lordship.
You have a petitioner?
Yes, respondent, Your Lordship.
Respondent?
Yes,
Who's the petitioner?
Yes.
Respondent?
5, Your Lordship. School
5.
Managing Committee.
School matter?
Yes, Your Lordship.
On pre-event by Mr. Letter counsel to petitioner number 5. Not objected to petitioner. This is matter after 2 weeks.
May it please Your Lordship. Lordship, I beg to make a mention of item number 4, Your Lordship. I'm appearing on behalf of Miss R. Datta, Your Lordship, legal aid counsel for this matter. Lordship, she is currently on legs, Your Lordship, before the courtroom number 2, Your Lordship.
Sprained her leg.
Lordship, okay.
She can appear online.
Lordship may have this matter next week, Lordship.
On pre-made by Miss has sought for accommodation on behalf of the learned counsel for the petitioner.
Lordship,
Legal aid counsel.
Lordship.
The legal aid counsel who is said to be indisposed. Accordingly, as prayed for, this is matter after 2 weeks.
2 weeks, Lordship.
Highly obliged, Lordship.
Supplementary list item number 1.
May I please, Your Lordship? My lord, this application under section 483 of the BNSS, read with sections as 37 of NDPS Act, my lord. My lord, the petitioner is under a custody since 147 days. My lord, he is arrested on 3/9/2025, my lord. My lord, earlier occasion, CD was called for, my lords. I think CD has come, my lord.
I have submitted the CD, Your Lordship.
What is the stage of the case?
Is this, my lord,
Your Lordship,
last occasion, just the custody was.
investigation is still going on, Your Lordship.
Investigation
Charge sheet
going on.
has not been filed yet.
Charge sheet not filed?
Not yet filed, Your Lordship. It's been 4.5 months. The statutory period is 6 months.
My lord, near about 147 days means 5 months about.
180 days?
180 days mandatory period, my lord.
Commercial quantity of crystal meth was recovered, Your Lordship, almost 2 kgs from his backpack near Burney Hut Bridge, Your Lordship.
But thing is this, my lord, before Pansas, he has been arrested, my lord. Pansas says, my lord, Annexer 3, my lord. Annexer 3, my lord.
Page 24, Your Lordship.
Annexer 3 is 24. My lord, para second, my lord, at about second but last line, at about 12:25 hours, the officers and as noticed a person matching the given description near the said bridge. The officers immediately intercepted him and asked him to disclose his identity. The person identified so and so, so and so. And last para, my lord, however, on the repeated question, so and so person admitted that he was carrying amphetamine, methamphetamine crystal in his bag. The alleged receiver of the goods was not present at the place of his interception. My lord, thing is this, my lord, when he was arrested, at that moment, my lord, this alleged good was not in his possession, my lord.
He admitted that it was in his possession.
My lord, the prosecution did not disclose how those contrabands was recovered. There is no clear conception. Here, Pansas also says, my lord, at the time of his interception, there was no contraband in his possession. So, my lord, he is innocent. My humble submission, my lord, I am innocent, my lord. Nothing was recovered from my possession. It is, of course, prosecution's allegation is this thing is commercial quantity. In that part, I am in custody since 147 days, and that part, my lord, after 180 days is statutory period. I am waiting, my lord. I will defend my case, my lord. I am abide by all conditions, my lord. Just only I am a very poor person, my lord. My family is not so, my lord. Why also a disabled person? I have a little baby in my home, my lord. So my humble submission.
Mr. Chaudhary, you Mr. Chaudhary?
Yes, my lord.
You have to understand.
Yes, my lord.
Section 37 is involved.
Yeah.
And you know, I don't have to spell it out.
Yes, yes.
What entails
the
provision of Section 37 when it comes to application for bail. Now, from the materials on record, whether you are in possession or not, but if there's an admission that you are in possession of such goods, forget about receiver. That is not the issue here.
My lord. My lord.
But since you are said to be in conscious possession, then Section 37 will apply.
My lord, another submission, my lord.
Because you have to convince, you have to convince the prosecutor, you have to convince the court that you are innocent.
My lord, my submission
If this court is made to
no
believe
criminal antecedent.
that is a different thing. And it's your own statement. That's, of course, in course of trial, it may not be taken into account. But as far as bail is concerned, where is the Panchnama?
Panchnama is at page 24, Your Lordship.
24
of the bail application.
What is seizure witness?
My lord, second para from middle. Last line.
Show me the seizure list.
The seizure list. Your Lordship, the seizure list in the city.
Heard Mr. Med Chaudhary, counsel for the petitioner. Who is the petitioner?
Petitioner, my lord, his Rima Hazarika is the wife of the accused person, my lord.
You want to go? Was submitted that this application for grant of bail under section 483 of the BNSS, read with section 37 of the NDPS Act, was filed on behalf of Shri Dilip Das, who was Dilip Das, her husband, who was arrested in connection with initially custom NDPS case number and which case was then registered as criminal NDPS case number 8 of 2025.
Yes, Your Lordship.
Was it registered as?
Yes, Your Lordship.
pending before the court of the learned special judge, NDPS, Ribhoi District, Nongpo. It is a submission of the learned counsel that the accused husband of the petitioner was allegedly intercepted by the MD, was intercepted by custom officers on 3/9/2025 at about 12:30 p.m. or so at near Umtru, New Bernihat Bridge, Ribhoi District, and thereafter was allegedly arrested on the ground that he was caught to be in possession of contraband substance weighing about 2 kgs or so, which is said to have been found from a backpack he was carrying. Next, the learned counsel has however submitted that the said allegation is not correct, inasmuch as the accused person was never in possession of the said bag, and there was no proof that he was in possession of such contraband substance. However, since the accused person was arrested under the relevant provision of the NDPS Act and is now in judicial custody, being a laborer by profession and also the sole breadwinner of the family with no criminal antecedent, it is therefore prayed that this court may be pleased to enlarge the accused person on bail with any condition as deemed fit and proper to be imposed. Per contra, Mr. Learned Counsel appearing for the respondent, Union of India, representing the custom. You are representing the custom department. Representing the custom department has strongly opposed the prayer made on the ground that there are ample proof. There is ample proof that the accused person was caught in conscious possession of the said contraband substance, which was found by the officers who had conducted a search on his person, such contraband substance being found contained in a polythene bag, which was kept in a said backpack. In fact, from the Panchnama, it is also clear that the accused person has admitted that he was carrying such contraband substance in his said black bag. No? Accordingly, in view of the provision of section 37, where the seizure of the said contraband substance is of commercial quantity, there being no counter proof on behalf of the accused person to show that he is innocent. Therefore, the prayer for grant of bail is therefore the prayer for grant of bail may not be allowed. Submits the direct counsel. This court, upon hearing the parties, has also perused the said Panchnawa, which was also annexed with this petition, as annexure 3.
Annexure 3.
At page 24, as annexure 3. On perusal of the contents therein, it is seen that the accused person had indeed admitted that he was carrying the said contraband substance in his black bag. Though such admission would be tested at the time of trial, prima facie, this court is this court is convinced that the accused person was indeed in conscious possession of the said contraband substance. Admittedly, since the said seizure is of a commercial quantity, the provision of section 37 of the NDPS Act would come into play. There is nothing to convince this court. At this point of time, there is nothing to convince this court that the accused person is innocent of the offence alleged. Accordingly, there is no merit in this petition. It seems hereby dismissed and disposed of.
Item number 2.
Yes.
This is a case where though listed for hearing, there is an application for amendment.
Yes, yes.
And it has been pending for a long time. They took a lot of time to file their objection. My lord, at least your lordship allow the amendment application, my lord. What happened, my lord, briefly the facts of the case. The appointment of a lecturer is under challenge. As she has been arrayed as private respondent. So we have challenged the, my lord, her appointment on the ground that her name appeared at serial number 2, whereas writ petitioner appeared at serial number 1. That was the case. Now during the pendency, what happened, my lord? Further, the appointment has been confirmed by the government. So this is the same cause of action. Appointment is under challenge. This is only a formality, your lordship, that confirmation. Now that confirmation part we want to insert into the writ petition. That is my prayer. And if your lordship, my lord, on amendment, numerous judgments are there. This court should be very liberal.
Yes,
and same cause of action, my lord. Allow me, let me file a consolidated petition.
Why would we see? We go into a multiplicity of
exactly, my lord. Those things are here. Multiplicity of proceedings. So allow me that. I will have to prepare a consolidated petition, my lord. I will file it.
Who's appearing?
Is the page number? 21.
Mr. Paul, you are for respondent 4 to 8.
4 to 8, my lords.
And 9.
And where is that?
And who else is appearing?
1, 2, 3. Show the victim.
State.
Show the state.
Yes, who's appearing first? No, are you appearing? AG is there, but where is he?
So far, my lord, there are objection only from the private respondents. There is no objection, no affidavit filed with the government. Government has not objected. They have not filed any objection to this.
Mr. Paul,
My lords.
we allowed the amendment. And you can file your counter.
Yes.
My lords, what we are saying is, my lord, it gives rise to a fresh cause of action,
True, but
which was not assailed in the original writ petition.
But if I can understand correctly,
What is confirmation has been defined. I just read out, my lord. What is confirmation?
Sen has submitted.
Well,
It's a
Continuation of the
It's a
appointment.
continuation of follow up of the initial.
This is my lord can still 49. Already given, my lord. 49 page paragraph.
Mr. Paul, either here or there, you still have to defend your case.
no, that I will, my lords, that I will. But the issue here is, my lords, as your lordships are aware, insofar as amendments are concerned, amendment of a pleading is in the writ petition is concerned, my lords. If it gives rise to a fresh cause of action, then it would tantamount, my lords. What would basically essentially do is file a fresh writ petition incorporating that in a.
He is challenging your appointment, isn't it?
No, my lords. I am the college authority. My lords.
Oh, you're a college.
I am the college.
Then who is the private respondent?
Private respondent is my learned friend is defending, my lords.
Or you responded to 1-9? So,
No, my lords, I am on a different setting.
I understand.
My lords may hear us on the issue of my lords,
I am
amendment.
ready for that. Lordship will hear. Lordship is not taking up the hearing. First, your lordship will decide this.
I'm saying that only, my lords. Only on the issue of amendment, my lords may hear us. We'll place the law to what extent amendment would be permissible in law.
Exactly.
So, my lord, in this case, my lord, I will just rely. I will not trouble my lord with too many. 2006, 12 SSC 119. I have given a copy. Paragraph 21. There are numerous decisions. 2006. SSC 119. Paragraph 21. This general principle laid down by Supreme Court has been reiterated.
This one.
My lord, if I can just read it. Well, Para 21.
Yes.
Lordship, may I read it? Principle governing amendment of pleadings are well settled. Order 6, Rule 17 deals with the amendment of pleadings and provides that the court may at any stage of the proceeding allow either party to alter or amend the pleading in such a manner as on such terms may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties. It is right that though an amendment cannot be claimed as a matter of right under all circumstances, yet power to allow amendment is wide and can be exercised at any stage of the proceeding in the interest of justice. It is equally well settled that unless serious injustice or irreparable loss is likely to be caused to the other side, the court should adopt a liberal approach and not a hyper-technical approach, particularly in a case where the other side can be compensated with cost and dominant, subject to allow the amendments. Nevertheless, one distinct cause of action cannot be substituted for another, for the subject matter of the suit can be changed by means of an amendment. Now, my lord, here your lordships, what it says should be liberal, and then, my lord, for actual determination of the issue. Now, actual determination of the issue is what, my lord? The appointment, the way the appointment has been made, my lord, divorce of the rules, the appointment is under challenge. Now, during the pendency, this appointment has been formally confirmed. So, my lord, this is only a formalities has been done. What your lordship is required to decide, my lord, the appointment, whether the appointment has been legally made or not. That is the issue. So, my lord, this is a case, my lord, squarely covered by this proposition of law. Now, secondly, my lord, what is confirmation? Another decision I have cited, my lord, that has been defined by the Supreme Court. In 1975, 1 SSC, page 843, my lord. Relevant paragraph is paragraph 49.
49.
49.
Yes.
If I can read. The confirmation of a person appointed to be or promoted district judge is clearly within the control of the High Court for this reason. When a persons are appointed to be district judge or persons are promoted to the district judge, the act of appointment as well as the act of promotion is complete and nothing more remains to be done. Confirmation of an officer, my lord, I will stress here, on successful completion of this period of probation is neither a fresh appointment nor completion of appointment. Such meaning of confirmation would make appointment a continuing process till confirmation. So, my lord, it is very clear, my lord, this is not a fresh appointment at all, my lord. This is a mere formalities. So, my lord, this is a case, I am not, my lord, seeking any further amendment. Only that part, my lord, the latter issued I want to annex. And we are saying since the appointment is long, my lord, subsequent confirmation is also wrong. That is that much only. So, my lord, this is a case, my lord, will not recourse to hyper-technicalities, your lordship, needs to be allowed.
Yes, Mr. Paul.
Lords, may only allow me a day's time to respond to what my learned seniors argued. I'll conclude it tomorrow, my lords. Because I'll just place 3 decisions, my lords, including a decision of this honorable court in the issue of, my lords, when amendment is to be permitted, and to that extent. My lords may hear us tomorrow, my lords.
Tomorrow?
Subject to my lord's convenience, of course.
I don't think tomorrow I don't know. I'm just
tomorrow
saying.
There is a reference.
There may be a.
There is
a reference, my lords.
Full court reference.
So.
Tomorrow. Day after, whatever, my lord, convenient to your lordship. Only thing, my lord, this is pending for lordship looks into the records. They have to take certain number of adjournments to file their objection.
My lords, may I have it on Monday, my lords, next?
No, Monday, my lord, I have some other part-heard matter.
Tuesday?
Is that EPFO?
Monday or Tuesday, my lords?
Not Monday.
Monday, my senior has some difficulty.
Up it's South like
those appeals are there, no? Division bench.
Fourth. Heard Mr. SN, counsel for the petitioner, who has made his submission on the application for amendment of this petition. Mr. K. Paul, learned counsel for the respondent 428, has sought for time to respond to the same, to the said submission. Mr. learned counsel, appearing for the respondent number 9, has submitted that the respondent number 9 has no objection to the amendment if so made. Mr. K.P. Saji, learned G, appears for the respondent. Are you appearing for all the respondent 1, 2,
3, my lords?
For the respondent number, state respondent 1, 2, 3. As prayed for, this is matter for further hearing on 4th.
4th, my lords.
Acknowledgement.
Item number 6.
Just photo.
My lord, this is a promotion matter. My colleague, Ms. Oliver, informed me that she is in courtroom number 2 and will be joining soon. Shall I proceed? If Lordship permit me to proceed, I can proceed, otherwise, my lord. The promotion matter.
Okay. MIDC.
MITC.
Mr. Sen, you are appearing for?
I'm for the state, my lord. My learned senior is appearing for the MIDC.
And number 4 is my friend, Mr. KP. Number 4.
Who's responded for?
Number 4 is the director. Current MD. Current MD.
Whose promotion the petitioner
We have challenged.
Okay.
Yes. And number 5 was the outgoing managing director.
Outgoing manager.
Managing director. He retired already. And represented by my friend Olivia.
Okay. So
Olivia is in court number 2.
what do we will? What did she say?
She said that she would be joining later.
You can start.
Yes. The issue involved in this case, my lord, we are challenging the promotion of the respondent number 4 to the post of managing director of the MITC. Now, there are 2 sources for appointment to this post.
Yes.
One is from the department, from the corporation itself. One is from the outside. From the outside. So if it is from the outside, government has the liberty to select either from within the corporation itself or from the outside. If from the outside,
is it on deputation or direct recruitment or?
Yes, that is up to the government. They can lift it from any senior IAS officer to man this post. But now when the government decided to appoint from the corporation itself, there is a service rules and articles of association. And if we go with that, my lord, it is based on is a promotional post based on seniority, reading with the APAR, ACR. Now the issue here, the private respondent and me were appointed on the same date. But number 4 did not join, but I joined. 1 week before the joining of the...
Any DPC proceedings?
No, not DPC.
How was the process conducted?
The process, my lord, we have seen the record. Normally, as per the record, as per the rules, ACR need to be placed. It has to be screened and examined, and accordingly, further action would be taken. In this case, admittedly, my department itself said that they never maintain ACR from the inception of the corporation. Now, what they have done, my lord, the board called for a meeting, and the board forwarded 3 names, including me, private respondent number 4, and other. And 3 out of 3, petitioner is the senior most. Though appointment was same date, but they joined 1 week after me. So service as per the rule commenced from the date of joining the report. And they don't dispute this. Government did not dispute, corporation did not dispute.
So your main ground is on seniority?
Seniority. And now the respondent said...
What is the mode of promotion? Seniority come merit or merit come seniority?
My lord, it is not spelled out by the rule itself, but ACR is there.
But what was the mode adopted? What was the manner the promotion was?
My lord, though the service rule do not specify merit come seniority or seniority come merits, my lord, but the ACR is there, my lord. ACR is there.
ACR would speak of merits.
Yes. Now, admittedly, neither the petitioner's ACR nor the private respondent ACR was prepared. It is not available. Now, only the board say that these three are the holding the post, eligible. However, out of these three, private respondent number 4, having a higher qualification, is a prominent candidate. So that record was forwarded to the government, and government has appointed the respondent number 4, who is junior to me. Now, if we go by the records, from the day one, whenever government lifted from the corporation itself, seniority is the basic. Some of the officers who were appointed from the corporation itself, only the seniors were appointed. Seniors were appointed. Now, if I may take a lordship, therefore the issue here, legal issue is whether the action of the respondent is correct, appointing the junior, leaving aside the senior, in the absence of the ACR. If the service rule says the matter is a merit comes seniority, and on merits, on the basis of ACR, he is meritorious than me, then I have no case.
But what is the observation or distinction made? There must be some observation. You see, when suppose a person who's junior in rank, or in terms of appointment, is considered, or rather preferred over somebody who's senior, and you more often than not, there would be an explanation.
Yes.
That because of such and such a reason.
Yes.
So he was.
Yes. Yes.
Is there anything?
It is not there. It is not there. Only the board resolution say that three of them are available. We are forwarding the 3 names for consideration to the government. However, the respondent number 4 is a prominent candidate in view of his qualification. Now, 3 of us already has a qualification. He has an extra qualification. But the service rule do not give any weightage for that. Distinction is made by the service rule. It is not there. Now, Lordship is correct, my Lord. When they said for TPC, there's a remark, there's a minute that in view of this position, Mr. A is entitled to be appointed because the C, B, C, D, they are not entitled because of this reason. That is maintained, my Lord. It is not here in this petition. Therefore, the basic issue is, my Lord, from the day one, they continue to appoint the senior most from the corporation whenever lifted among the employees. But here, my Lord, there is a departure. Despite of the seniority, they ignore it and appointed the junior. That is the issue, my Lord. If I may please a few facts, my Lord. My Lord, may kindly see page number 20 of my petition, the appointment. Appointment order, page 20.
Yes.
My Lord, appointment order was issued on, my Lord, 1st June 2004.
Yes.
And after 1 year probation, my Lord, it was confirmed by order 27 June 2005. That is page number 23.
Appointed as?
Appointed as, my Lord, the assistant manager. They were born in this category.
It's a cadre post.
My Lord. My Lord, can you see page number 23? Merit office order. Page 23. It says Sri Rigaksaj Moment on successful completion of his 1 year probation period on 6 June 2005. He is hereby appointed as assistant manager in the office of the MITC with the pay scale of such and such per month plus other allowances as admissible under the rules of the corporation currently in force. With effect from, it is important, my Lord, with effect from 1st June 2005, they should have been, my Lord, 1st June 2004. Is that the mistake is there? It is 2004, not 2005. Subject to the following terms and conditions. So he was confirmed.
No, you said 1st June 2004.
1st June 2004, 2004. But they mentioned 2005. It's a mistake, madam.
Where's the...
Madam, the correct one is...
corrigendum?
Madam, corrigendum is not there, but in the subsequent paper, madam, it is shown correctly. if my lord come to page number 30, the curriculum vitae, the service document of the petitioner, page 30, serial number 2, assistant manager, my lord, 1st June 2005. I'm sorry, my lord, it's incorrect. My lord, I'll come to.
Yes.
Well, just
this is correct then.
Well, stand corrected, my lord. Just show. My lord, the clearer one, my lord, page number 47. Service record of the Deputy General Managers that they have mentioned. Serial number 3. My lord, can you see Rigrag moment?
Yes.
Date of joining. My lord. 1st June 2004.
Yes. Date of promotion to assistant managers.
Yes, the subsequent date.
So, nothing wrong. 2005, you were promoted as assistant.
Promotion is correct, madam. Promotion is correct, madam.
So, this initial appointment is
assistant manager.
Assistant manager.
Assistant manager.
And why is here is it?
It should be incorrect. It is incorrect.
It's incorrectly recorded in the service records. It's a promotion. It is not a promotion. That was the first posting.
Yeah, exactly.
That was the first substantive post that was held by the petitioner.
Yes.
So it is not a promotion.
Then
it is the confirmation of the appointment of the expiry of serving as a probationer. And it should be with effect from, my lord, 1st June 2004. That is a reveal in page number 47.
Okay, okay.
Yes. Now, thereafter, my lord, all of them, my lord, they were appointed and he joined. My lord, may I come to page number, my lord. To show the seniority, my lord, may I straight come to page page 47, my lord. Itself, I'll show, my lord. Now, serial number 2 is a private respondent number 4 who was promoted.
Okay.
Serial number 2 in page number 47.
Yes.
My lord, date of appointment are the same, my lord.
Yes.
Now, date of joining, my lord.
Yes.
Date of joining, my lord. Serial number 2, Dalini M. T. Numali. Date of joining is 14 June 2004. And serial number 3 is the petitioner. He joined on 7 June. So 1 week senior to him. And number 4 is another recommendee, we can say. My lord, Sangma.
Yes.
He also joined on 14 June. So in terms of seniority, my lord, he is senior, 1 week senior to both of them. And they don't dispute that one.
Okay.
And thereafter, what happened? There was a vacancy arose. And in view of that, my lord, page number 42, the board called for a meeting.
Page
number 42, 42, Annexure 5.
Yes.
Well, this is, my lord, the 238th meeting of the board of directors, which was held on 23rd December 2022.
Yes.
And may I come to agenda number 8, page 43. Superannuation of a managing director, Sri Jake India, and board recommendation for successor. It says, the board was informed that the present managing director, Sri Jake India, will be retiring on 31st March 2023 on attaining the age of superannuation. The list of senior officers of the corporation has been presented to the members along with the detailed curriculum vitae, CV, and service records. The managing director also presented the revised curricular Vishya of Sri Rigrag moment. The board members then carefully scrutinized the CV presented and noted that the date of appointment of Sri Rigrag C. Moment, Sri Did Nongmali, and Sri Sangma is the same. Date of appointment is the same. It also noted that all the above officers were appointed to the corporation on probationary basis, and after successful completion of their 1 year of probation period, they were appointed as assistant manager. However, as probationer, Sri Rigrag Sage Marak joined the corporation on 7 June 2004, while Sri Nongmali and Sri Sangma joined 1 week later. The board also noted that the mentioned officers were qualified Bachelor of Engineering. So this is education qualification under the rules. All of them were qualified engineers, but only Sri Nongmali holds an additional qualification in master degree on MBA. Now this is the only extra qualification she has. But under the rules, all of them are engineers, but that fulfill the requirements under the rules. Now, after thorough deliberation, the board members decided to forward the names of 3 general managers, Sri Sansa Sangma, to the government for appointment to the next managing committee director of the corporation. They have forwarded. In addition, the members of the board felt that out of 3 officers, Sri Nongmali is more prominent for the post. Now, this is not a recommendation, it is only forwarding the records, because the service rule never empowered the board to recommend. Board is not a recommending authority. The board, being the highest body of the corporation, they said there, record was placed by the serving managing director, and scrutinized it and forwarded 3 of them. Now, in the counter affidavit taken by the state, they said, we did not challenge this. According to me, my lord, this paper do not confer any rights to any one of us. All the 3 were sent. If, my lord, I was denied, or even Mr. Nongmali was only forwarded, and we were 2 of us excluded, then we ought to challenge this. But 3 of us, being a serving officers, forwarded the records. So it is not challenging to this paper. Minute is not fatal to the repetition. Now this was the use of the word recommendation. In some paragraph, they said forwarding, my lord. It's only forwarding of the paper, service paper. Thereafter, my lord, if my lord kindly see page number 44. This was the letter, 15 February. Page number 44.
44. Yes.
This is a letter, 15 February 2023. This is written by the director now. It says, we are enclosing here with the minutes of the 238th Board of Directors meeting of the corporation held on 23rd December, the one we read out, my lord. Such, known in the board room of the corporation, Lai Tumkara, Shillong, for favor of information, comments, views, if any, may furnish to this corporation at least. Now he has serving director has forwarded these minutes to all of them, all the board members.
Okay.
And the board members, my resolution is started from page number 47, 45, sorry, 45. 42. 45. And page 45, my lord, from the beginning, agenda 1, 2, 3 are correct, is the same. But if lordship can continuation of page 46, agenda number 8, the content is, my lord, the content is different.
Yes.
Therefore, we implemented the outgoing managing director, who was the one who flouted the records. Now, when we compare this page number 46, and page number 43, lordship can see, agenda number 8, page 43 also, agenda number 8 of the same minutes.
Yes.
My lord, can you see? Page number 43, agenda 8, this is the minute of the board, they see. And page number 46, it is different.
Yes.
It is completely different. So therefore, the action of the serving director, who was in favor of the respondent number 4.
But why, you see, what is wrong with this? See, the board can sit, you see, in its meeting, one meeting after another.
Yes.
Resolution can be passed, maybe passed separately. Subject matter may be the same, but you see, the deliberation would be different.
Right.
And the resolution passed would be different.
Madam, if they held in different dates, madam, but the same minutes. This was held on 23rd December. Madam, it's page number 42.
On the same date?
Same date.
23rd December.
Yes. And my lord, again, it's page number 44. So they are forwarding the minutes of corporation page. They held on 23rd December. It is the same minutes.
Okay.
But different contents. That indicates the ill intent of the serving managing director. The other part, my lord, I have shown, my lord, the seniority position among 3 of them, page number 47. I have shown already, my lord. Yes. Now, thereafter, my lord, government asks for the, my lord, page number 53. Okay. Has forwarded, my lord, the director has forwarded page number 53.
Yes.
Forwarded the same minutes, my lord, to the secretary, to the government. 17 February 2023. And second paragraph, may I think, my lord, the matter was placed before our board of directors at its 230th meeting held on 23rd. It should be 23rd, my lord, not 22nd. December 2022. But which will thoroughly discuss the issue and decided to forward the name of all the 3 senior officers, the rank of deputy general manager for appointment of next director of the corporation. In this connection, extract of the above board meeting resolution along with the file data and service record of all the 3 general managers were enclosed here with for considerations. So all the 3 were forwarded by the director, serving managing director. And the agenda, my lord, page number 54, the agenda 8 was reproduced by him, lifted from the minutes.
Okay.
And thereafter, my lord, page number 50, my lord, 55 onwards, these are the service record showing the seniority position, joining position, and that is undisputed, my lord. I come to page number 60, my lord, service record of deputy general managers, page number 60. This one, accordingly, they have arranged as per the seniority. Page number 63, 3 officers were there. My lord. Yes. Number 1 is the petitioner.
Yes.
Date of appointment same, but the date of joining is different.
Yes.
But now, the page number 61, government sought for gradation list, because the board has to refer the 3 officers to the government for consideration. Therefore, government did not choose to appoint from outside, but decided to select from the corporation employees. Therefore, they asked for the gradation list, page number 61, letter mail 13 March 2023. It says, madam, with reference to subject and letter number cited above, you are hereby requested here furnish a copy of gradation list, qualifying service and annual confidential reports of the incumbents for the post of managing director, Meghalaya MITC, for further necessary action from this end. So, government sought for. Now, the page number 62, Director of Commerce has forwarded to the MIDC the same letter, and the page number 63, Managing Director has responded to this. Letter 20th March 2023.
62?
62 is 62 is the same letter authored by the government was forwarded to the Managing Director by the Commerce Director, Director of Commerce, for response. In persons, there to my lord, page number 63, the Managing Director of the MIDC has responded. Now it says, my lord, with reference to the above, we are furnishing here with copy of the gradation list and qualifying service of the incumbents for the post of managing director of this corporation has decided. The practice for maintaining of the annual confidential reports by the corporation has not been done since inception. So they have spoken to one gradation they have forwarded, we have prepared, we are forwarding to you, but ACR from the inception we never maintained. So it is difficult for the government to ascertain the competency of the candidates without the ACR. Therefore, my contention is the government has to go by the seniority, and which they have done earlier also in a number of occasions. This was the letter, and the gradation list is, my lord, page number 64. Page 64, the next page. My lord, in the gradation list, my lord, the seniority of the writ petition is visible there. Serial number 1. 3 of them were there. In view of the date of joining, my lord.
Yes.
7 June, other 2 gentlemen, 14 June. So this is the gradation maintained by the corporation, MITC. So they are not disputing the position. And fairly, my lord, private respondent also did not dispute that I joined earlier than him, than me, or he joined with me. He considered that yes, writ petitioner joined earlier than me. So this is the gradation list position. Now, again, my lord, the government, page number, my lord, the page number 868, forwarded, well, page number, I would take page number 67, my lord. Government again reminded or requested the MITC to provide this ACRs by letter, my lord, 5th April 2023.
Yes.
And Director of Commerce and Industries has forwarded the same on 12th April 2023. And again, my lord, page number 69, the Director of MITC, my lord, the Deputy General Manager of the MITC has forwarded, my lord, this. Yes. In connection with letter sentence, we'd like to inform you that MITC Limited, being a limited company, state undertaking, the practice for maintaining of the annual confidential reports, ACR, has never been done since inception. So the same reply. Same reply. Now, shockingly, my lord, page number 71, this is the impugned letter. Instead of going with the, on the basis of the seniority, they have appointed the private respondent number 4. My lord, that is 25th April. My lord, in persons to powers conferred, my lord, under Article 62.2 of the Memorandum and Articles of Association of Meghalaya Industrial Corporation Limited, the Governor of Meghalaya is pleased to appoint Sri Sansach, Deputy General Manager, to the post of Managing Director, Meghalaya Industrial Corporation Limited, with effect from the date of taking over charge and until further orders. Sri Sansach, who has retired after attaining the age of superannuation on 31st March 2023. So he was appointed.
Yes.
Now I would show, my lord, before I go to other aspect of the matter, the practices of the past, in the past also, may come to, my lord, the service rules and articles of association.
Page.
Now, my lord, may I take lordship attention to my rejoinder affidavit, which we have annexed the detail. Rejoinder affidavit, which we have filed on 27 July 2023. There we have annexed both the articles of association and service rules detail.
(27/7).
My lord, 27/7/2023, my lord.
Yes.
My lord, Articles of Association start from page 11, my lord, Annexure 1. Page number, my lord, 11.
11?
Page 11.
Of your
Of my rejoinder affidavit. Memorandum of
Sorry.
Memorandum and Articles of Association. Rejoinder affidavit on behalf of its petition reply to the affidavit in opposition filed by the state respondent number 1 and 2.
Just a moment.
A number of affidavits also filed by the other sides.
Yes.
Well, my lord, we come to page number 20. Definition of bylaws are there. Definition clause. My lord. Article, my lord. Sub-article J of Article 1. Definition of bylaws are there.
Bylaws.
Bylaws, my lord. And that service rule is one of the bylaws. I'll come to that one later. Now, may I come to that page number 33, my lord. Article 62. Page number 33, which is quoted by the governor in his appointment letter.
Board of Directors.
Well, Board of Directors, my lord. My lord, we come to Article 62, appointment of chairman, managing director, and other directors.
Yes.
It says, my lord, the governor shall have the right to appoint the directors. So, appointing authority is the governor is the appointing authority. Now, number 2. Article 2, my lord. The governor shall appoint one of the directors as the chairman and any other directors as co-chairman and another one as the managing director, either for a fixed term or without any limitation as to the period for which he is to hold office. The governor may appoint one of the directors as a whole-time director, either for a fixed term or without any limitation as to the period for which he is to hold office, provided that the managing directors shall be appointed in consultation with and after obtaining the advice of the IDPC. IDPC is, my lord, Industrial Development Bank of India, my lord. Now, number 3, my lord. The chairman, the co-chairman, the managing director, the whole-time director, and other directors shall be paid such salary and or such allowances as the governor may from time to time determine, subject to the provision of sections of the Act, is the Company Act, my lord. Such reasonable remuneration as may be fixed by the governor that may be paid to any one or more of the directors for extra or special service rendered by him or them or otherwise. Now, my lord, number 5, may I come? At every annual, my lord, meeting of the company, all the directors, including the chairman and co-chairman, except the managing director and the whole-time director, shall retire from office. The managing director or the whole-time director shall retire on his ceasing to hold office of the managing director or the whole-time director, as the case may be. A retiring director shall be eligible for reappointment. Now, here, my lord, the governor is the appointing authority. Now, he can appoint, my lord, chairman, co-chairman, and other directors also. And there are 2 directors who are holding permanently. One is managing director, another one is the whole-time director. Now, the rules, my lord, the Sub-article 3 says salary, such salary or other allowances. My lord, a person lifted from the commerce department or any other department and put there, my lord, he will not withdraw the salary from the corporation because he's drawing salary from his own parent department. Therefore, it is called allowances. Allowances come into picture. But if my lord, a person is lifted from the corporation itself, that person is entitled to get salary under the service rule. Therefore, the article has prepared in such a way that it deals with the two situations. Now, we are not disputing the power of the governor for appointment. But our contention is that once you, my lord, the government selected to appoint from the corporation, you have to read with the service rule. Now, service rule was ignored by the governor and only exercised his own power and appointed the private person. Now, may I come to service rule? What does service rule says, ma'am?
I think, Mr. We'll have to continue next day. Now, heard Mr. H.L. Sangreso, Leonard Senior Counsel for the petitioner. Hearing is not concluded and will continue on the next date fix. This is matter up to 2 weeks.
Okay.
Item number 12.
The last.
May it please your Lordship. Lordship, I think this matter has become infructuous because what happened, the person has been arrested, your Lordship.
Lordship, my senior is on his way, Lordship. Mr. Paul will address this court now.
Do you have any challenge about the law?
Yes, Mr. Chanda.
Because the bail has been cancelled.
Bail cancelled. You have come against
that order of cancellation.
Against the order of the Constitution. But in the meantime,
he has been arrested, your Lordship.
I have no instructions, Lordship. He's
My apologies.
What do we do, Mr. Paul?
Well, this matter pertains to cancellation of bail. We are saying that the procedure to be followed in respect of cancellation of bail has never been followed by the state authorities. Now, in the meantime, what has happened is, I'm informed that the petitioner has been arrested yesterday, even though there was a direction for him to appear before the RI police station, in terms of an order passed by the Honorable Supreme Court. So that is the position as we are faced with as of today,
What do we do?
I would say that this matter would survive because, the validity of that order is under challenge before my lords. And, your lordships are aware.
Whatever the case may be, even if the impugned order of cancellation is set aside, suppose it's set aside, the fact remains that subsequently he has been arrested.
True,
So that is a fresh cause of action.
Now
you have to apply for
regular bail. That's the first impression even I had. But there are two aspects to this order, If I can just draw your lordship's attention to the operative portion of this order.
Of which order?
Of the impugned order before my lords. It's page 86.
Yes.
The second last paragraph, my lords.
Yes.
The bail granted to the accused Gopal Krishna Gaur by order dated so and so is hereby cancelled. The accused is to be arrested and taken into custody in accordance with law. Now, my lords, I am on the second part. One is, my lords, cancelling the bail. One is there is a positive direction by the court to arrest this accused. Now, that aspect of the matter, my lords, in my humble submission, will keep this matter alive. Because the other thing, my lords, which is really unfortunate in this matter is that this matter had last come up before the vacation bench.
Yes.
And it was on the prayer of my learned senior that the matter was fixed today for hearing. Because, my lords, at that stage also we had made a specific prayer that only for that limited one day some leeway be given to me so that I can come and appear before the Araimal police station in terms of the directions of the Honorable Supreme Court. Now, yesterday, my lords, when I land at Guwahati airport, CISF detains me. My lords, and that also in Assam. Part 1.
Yes.
Number 2, my lords, they are conscious of the fact that this matter is coming up before my lords today for hearing on this issue of cancellation of bail. Well, what baffles us is what was the tearing rush to arrest this man, whereas there is prior intimation that he is appearing before a concerned police station on the 29th. And your lordships are hearing us today in any case. So, well,
see, Mr. Paul, the fact remains that there is no interim order.
Well, it's true. There was an interim order that was being passed.
By this
no, my lords, by the vacation court. Opposing that interim prayer, my lords, they said, please don't pass an interim order, let the matter be fixed on 28th.
Okay. But the fact remains that where's any order pass?
Well, it simply says that the matter is fixed by consent of both the parties today.
Okay.
Now, what is happening is, my lords, if the state is making an effort to, my lords, overreach the directions passed by this Honorable Court, my lords, it's very unfortunate. What does a man do?
But you know very well, the fact remains that the court cannot read between the lines.
My lords, I would say this is way beyond the lines, my lords, it's apparent. Your lordships are hearing us today. The man has, my lords, given an intimation that I'm coming to appear on 29th. In terms of a Supreme Court order, which again, my lords, is passed in the presence of the state. When I land at Guwahati, my lords, the CISF arrest me out of 4-0. I'm detained in some third state without there being anything against me. And the more astonishing part about it is, my lords, there is no warrant of arrest as against me. So I would humbly pray, my lords, my lords may kindly hear us on this main issue. Of course, what has fallen from your lordship, my lords, that we have to be conscious of the fact that now that I am in custody, there would have to be, my lords, some application of mine by a concerned magistrate. But then what would happen to this order, my lords, which has been passed against me? This would act as, my lords, it would prejudice me in any subsequent applications. That your lordship will kindly appreciate. Because any court would then say, my lords, that you originally granted bail, but that was subsequently cancelled.
Well, we have to cite authorities and precedents then. Under such circumstances, what would be the
proper course of action?
Role of the court, rather. Yes.
DK Basu is very clear, my lords. DK Basu and Arnesh Kumar. Because the other thing is, Arnesh Kumar, your lordships are aware now, which is holding the field. That they say that the police will also have to record, my lords, reasons of arrest and non-arrest.
That will not be applicable, your lordship. Arnesh Kumar case, it will not be applicable here, your lordship.
Even that issue has not been decided whether it means arrest in the first instance.
Yes, your lordship. That is what I would like to
which is
submit,
what, my lords, my second limb of argument is. My lords, as your lordships are aware, at this stage of investigation, the police take cognizance, which says my cognizable, non-cognizable. So you take cognizance of a matter, you arrest a person, and my lords, once you arrest that person, he is granted bail by a competent court. Subsequently, my lords, you move the competent court for whatever reasons, my lords. I have not cooperated with the investigation, and you seek my cancellation. My bail gets cancelled. Now, my lords, then the question arises whether the power of acting, my lords, independently will then still vest with the court, will vest with the police. That is a legal issue, my lords, that my lords would have to answer. Which is why I pointed out the last operative portion of the order, my lords, which says bail is cancelled is one part. Then the court says you take him into custody. What I would then, my lords...
that is a let's put it this way, a follow-up action.
My lords, that follow-up action, my lords, in my humble submission, will then have to be met with something else. There would have to be, my lords, a warrant issued by that court.
Well, the procedural aspect, that's a different thing.
My lords, that's the other issue, my lords, which we need to urge before your lords. My lords, may I just pray, your lordships may have this matter tomorrow. I'll examine the law, I'll place it before your lordships.
After. This day after. Tomorrow
I think tomorrow is
I have some difficulty
tomorrow is the
tomorrow.
reference, isn't it?
Reference, my lords. They may not be
I
court.
don't know. Nothing has been said.
I'm informed, my lords, by the Registrar General that there is a reference tomorrow.
Oh, tomorrow will not be.
Because my humble submission would be, my lords, that
We'll
may I just pray, my lords?
We'll have it after a week then.
We can have it next week, my lords, and my lords may kindly permit me that, my lords, the pendency of this will not act as a bar for me to move an application there.
That is
that kind of observation is not called for.
That is up to you.
No, my lords, the difficulty would be then,
Whatever the case may be, seems upon you may move a regular bail.
if permissible by law, your lordship may note that.
Why should I say?
My lord, the difficulty is going to be, my lords, now your lordships have seen how this matter is happening. My lords, one incident, 8 FIRs filed. After, my lords, BNSS has come in, I am being tried under IPC. My lords, I tell them, Supreme Court says go. I tell them I'm coming. My lords, I'm picked up in another case when your lordships are hearing the matter today. In normal circumstances, my lords, I would not have made that prayer.
We'll take it up after a week. I'll not make any observation on the the rest, the correspondence that you have produced for this court. But I'll allow you to make state your case and we'll see.
My lords, I'd have to satisfy my lords on that issue. Because, my lords, this was something that was otherwise also, my lords, it was intriguing me that it is not purely a state, my lords, where there is a first arrest. Your lordships have rightly pointed out, it's not a case of first arrest. I am arrested, released on bail, bail cancelled by a competent court, which is under challenge before my lords. Now, my lords, whether I can be picked up by the police directly is an issue, my lords, I think.
Bail is a privilege, your lordship.
Anyway, like I said, the court would be more, interested or concerned as far as the procedural aspect is concerned.
Procedural aspect is concerned.
So whether it was done properly or not.
Because the other aspect is, my lords, on which we are challenging this order is, my lords, your lordships are aware, the law otherwise, as I can understand, is, my lords, that once bail is granted, in regular circumstances, it is not cancelled.
Well, that's a different.
Which is why, my lords, we say cancellation of bail is a different thing than non-grant of bail, my lords.
Yes.
Not granting bail is a different thing. Cancellation is a different thing altogether.
You have
here, my lords, the court does not permit me, does not say that fair enough. I will give you a date till so and so date till which you should either appear or else we will cancel your bail. Because that also the Supreme Court says, my lords, that an opportunity should be given for him to make himself available and surrender before the court. Be that as it may, my lords, may have it next week, my lords. May I pray for Monday, my lords, the second, subject to your lordship's kind convenience.
Monday. And third? On Monday.
Third.
Third or fourth, whatever you say.
Third, my lords.
Third will do, your lordship. Not
on premier by parties, this is matter.
Third.
For the hearing on. Third.
Lordship.
I was only praying your lordships give us that one line, my lords, that it will not preclude me to move.
You can go ahead and move.
My lords, the difficulty is because then, my lords, there somebody is going to say, take an objection that the matter is pending before the High Court.
No, nothing. You see, as far as the instant application is concerned, it has got nothing to do. It has got nothing to do with the substance.
I would only say it would not prejudice the state. It does not prejudice. What my prayer before your lordships is does not prejudice anybody's case. Your lordships are seized of the matter. If the law permits, my lords, I may be permitted to move an application under 439.
If the law permits, you don't have to seek the court's permission.
My lords, the only reason to seek that permission is because, my lords, your lordships are seized of a matter. Your lordships are fixing a date. It should not be one of those cases, my lords, where the court says.
In that case, the court will have to hear the parties and has to pass a reason order.
No, my lords, I am only saying that to that limited extent. Well, it would be to my detriment tomorrow if something I cannot buttress it. So I am only saying that they don't stand to be prejudiced in any case. I am not saying your lordships will, my lords, make any indication that he should be granted bail or anything like that. I am only saying that the pendency shall not bar me to move a bail application.
Nothing has been brought on record. as far as if I may say so,
But officially he's under arrest, my lords. There is an arrest memo. He's been produced.
then I have to take note of the.
Let it be taken note of, my lords. I have no grievance with that.
Then I have to hear the parties.
My lords, I'm only saying your lordships will hear us. Your lordships may indicate that we'll.
Matter will be taken on third. Third is
My
a
lords,
few days from now.
the difficulty is, my lords, it is concerning the
You take your
liberty of a
chances-
person.
Take your chances and see.
My lords, it's concerning the liberty of a person.
Exactly.
Otherwise, your lordships know, my lords, I would not press.
I understand. And this court is well aware of the importance of the liberty of a person.
My lords, I bow down.
Therefore, more often than not, you ask anybody here.
I can vouch for it.
As far as bail matters are concerned, this court would take it up on a priority basis.
My lords, I can vouch for it, my lords. I'm sure every member in the bar vouches for this.
Circumstances is such that the court cannot make an observation on your asking.
We'll have it on
We'll see.
on Tuesday, Your Lordship, on time.
My lords,
Either that or we have it on Friday. Then.
my lords, Friday, I have a difficulty, my lords. My lords, 1 year is coming to an end.
Okay.
That's the only reason. All else I would not have
Okay, we'll have
Tuesday.
then on
Tuesday.
on Tuesday.
Good morning to go.
Oblige, Your Lordship.
Any mention?
May it please your lordship. Lordship, item number 14. May I pray your lordship, this matter may be taken up on 4th, your lordship.
This is connected to the
lordship, yes.
13.
With 13 is correct.
With 13.
13
yes.
already
1,
heard,
3.
Your Lordship.
1, 3 and 14.
13 already heard. Yes, I think
Yes.
judgment is reserved, but we have to.
On 4, I'll complete, your lordship. I have some.
So you have to submit on premier by Mr. Should I direct AG? This is matter after 2 weeks.
Apply, your lordship.
So that's 13 also same.
Yes,
13. Apply, your lordship.
13 is thought same order.
Maybe please, Your Lordship, item 19. I think can be accommodated by next week, I think, Your Lordship. I'm for legal aid. The other side, I think I talked to Nakiselas, he was there. I intimated her. 19. Next week?
Next week. On premier by, this is matter after 1 week.
May it please, Your Lordship. Item number 11. I'm praying for 2 weeks' time, Your Lordship.
Yes, item 11, the premier by Mr. Arling Rod, counsel for the appellant. That is listed after 2 weeks.
Hello,
Please, Your Lordship. Lordship, item number 18, Your Lordship. After 2 weeks, Your Lordship.
Two weeks, huh? 2 weeks.
Hello, Your Lordship.
Hello.
Wait, please, Your Lordship. Your Lordship, item number 15 of the main list. 15, 1, 5.
Legal aid?
My lord?
Not legal aid matter.
Not legal aid matter, my lord.
Katuru, 2 weeks, huh? On premier by appellant.
Highly applied, my lord.
Wait, please, your lordship. Lordship, I beg to mention item number 7. Lordship, I pray that this matter comes after 2 weeks.
On premier by the petitioner, this is matter after 2 weeks.
Right, your lordship.
Lordship, I beg to mention item number 17 on joint request.
17.
17, that Mr. Sengupta is appearing in this matter, Lordship.
On premier by the parties, this is matter after 2 weeks.
2 weeks, Lordship.
3 weeks.
Please, lordship, I beg to mention item 5 and 6. It's a connected matter, lordship. Humbly prefer 2 weeks' time, lordship.
5.
5 and 6, lordship. Obliged, lordship.
This 2023 matter, I think. On premier by the appellant, this is matter after 2 weeks.
May please, Your Lordship. Lordship, I beg to mention item number 9, Lordship.
Who's there for the appellant?
Dr. P. Puja Agrawal, Lordship, but she's not here.
Have you sought their consent?
No, Lordship. Madam, be called, Lordship.
Let matter be called.
On daily list, item number 1.
This is an appeal against the judgment and order of acquittal, my lord. My lord, on the last occasion, my lord, may kindly see the order passed in the miss case number 35 of 2025, my lord. Order dated 10/11/2025. Miss case 35, my lord.
Yes, I think we have.
Yes,
My lord.
cause title needs to be changed.
First
But
title and my lord, to produce a proof whether she is the sister of the deceased or not, my lord. So, my lord, we have obtained a certificate from the Lord, my lord. The Lordship may allow me to place it, my lord.
Then you have to bring it by way of an affidavit.
Yes, yes.
My lord, we'll place it by way of an affidavit, my lord.
Legally,
Legally.
need to order. Direction is here.
My lord, in direction in the Miss Case 35 of 2025. Para 6, my lord.
Oh, this is 413 and 415.
My lord, leave to appeal.
Yes, my lord.
So we'll have to pass order in this miscase then.
My lord, the Miss Case is already disposed of.
Oh, you have disposed of?
My lord.
Yeah, yeah, I've seen it. Akadika mean Miss Ardata Leonard, Legal Aid Counsel, has submitted that, has sought for some more time to produce the proof of bona fide as far as the appellant is concerned, inasmuch as she is to produce adequate proof that she is the sister of the deceased victim. It is prayed that the relevant proof may be allowed to be produced by way of an affidavit. It is also prayed that some more time may be allowed for the cause title in this appeal to be modified accordingly. As prayed for, this is matter after 2 weeks.
Item number 2.
This is a criminal.
My lord, in fact, Lordship, before my learned senior begins, Lordship, there is a development in this matter, Lordship. Now, what has happened, Lordship, during the pendency of this contempt petition, Lordship, they have gone ahead and filed an execution petition before the executing court, Lordship, and that is proceeding, Lordship. So, in view of that, Lordship, Lordship, it is my humble submission that this matter becomes otherwise also infructuous,
My
Lordship.
lord, that is not the case, my lord. This is a altogether different proceeding, my lord. And moreover, hearing has already been concluded as far as this matter is concerned. My lord, maybe because of long time, was not able to recollect. So, my lord has asked me to refresh this matter once again. So, we could not take up on the last occasion.
Because,
also, my
Lordship, the order that has been assailed here, Lordship, that is a subject matter of contempt, has been, is the issue
That
before
is
the
not
executing court, Lordship.
Execution proceeding is
And they are
altogether
also
different
following
than
the matter.
contempt, my
It
lord.
has been contested, Lordship.
And moreover, my lord, this matter was already heard. And my lord has only asked again to refresh the memory of the court.
He was referring to recent developments.
No, my lord, this execution was filed long back, my lord, and then the matter is already proceeding. it's not now. It has been there, my lord, since many months, my lord.
Therefore, Lordship, in view of that matter, the contempt matter otherwise also becomes infructuous.
Why have you filed a contempt?
Yes.
Because certain orders of the authority or the court has not been complied with.
Yes, my lord.
Okay? Now, pursuant to that, you have filed an application for proper adjudication.
That is for violation of the orders, my lord. Right.
So, now, in the meantime, you have taken, or rather you have taken another recourse to another form of
Lordship.
Remedy, whatever, which is connected to the subject matter.
My lord.
That is for, if you say execution, in execution for the amount that
amount we recovered, my lord. Now, only question is, my lord, even there, my lord,
I don't know whether
every time, my lord, they are trying to delay the entire case so that they get the benefit. My lord, they are not.
There, my lord, we are contesting the matter in the right understanding, my lord.
If I am allowed just to refresh the memory of this.
In execution proceedings,
my lord,
we don't have to spell out what will be the outcome.
Yes.
Finally, if they are not able to pay, you seize their assets, whatever.
Yes.
So, in that way,
this matter may be otherwise kept pending, my lord.
Nothing survives, my lord, in my humble submission. This may be closed, my lord.
That is not the case, my lord. These are two different proceedings,
hear
my
the
lord.
parties.
For violation, my lord, that is under, my lord, Contempt Act.
This is just an observation of court.
Yes, that is true.
The party will,
If
the court will hear the parties, no doubt. You have to satisfy the court that these two proceedings can proceed
go simultaneously,
yes, parallelly, whatever.
Right. These two proceedings can go simultaneously, my lord. This is a contempt proceeding, that is execution, that is two different, my lord. This is under Contempt of Court Act, my lord. That is under different proceeding, my lord.
But the order which is pending
before
the executing court is the
my
same
lord,
order,
they are
lordship.
taking benefits of the delay, my lord. Since 2016, my lord, they have not paid the rent till today, my lord. And they are in possession of the property. If I can just refresh the memory, my lord, this matter was already heard, in fact.
My lord, in view of the execution proceedings being pending, my lord, I don't see, my lord, this matter being taken up, my lord.
You have to, you're just, you're just making assumption at the bar.
Lordship.
You have to, at least, if that is the case, then you have to file. You have to file something by way of an affidavit.
Yes, my lord. They
Lordship,
should come up with something that these two proceedings cannot go simultaneously.
Giving all those details.
Lordship. Lordship, allow me
objecting to the proceedings.
Lordship. Lordship, allow me a week's time. Lordship, we'll bring it on record.
Delay, my lord, the entire
Or Lordship, 2 days time. Lordship may be given for bringing on record the proceedings that is pending before the executing court. Lordship, we'll do that.
What do you say? We will give you only once to file. No adjournment will be allowed. This matter it's a contempt matter. I know
Yes,
why
my lord.
we gdragging on this.
Only to bring on record, Lordship,
If they would
the
have complied with the order, my lord, we have no issue.
application, Lordship.
Till date, my lord, they have not complied with the order also.
Lordship, that is why the executing court, the execution petition that they have
If
filed,
they have
Lordship.
any intention of complying with the order,
It
they
is
could
like,
have
Lordship,
complied.
they are going both ways, Lordship, blowing hot and cold.
My lord, that is two different proceedings. Law permits
It is
me.
not.
We'll take up this matter next week.
Lordship, next week. Lordship, may I kindly grant us liberty to bring on record the proceedings. Yes.
We'll allow you to bring on record whatever you want to produce before the court.
Lordship.
Advance copy to the other side.
Lordship.
And you can file your objection if any.
Lordship.
The matter will be heard.
Lordship.
At the outset, Mr. Chana, Learned Counsel for the respondent, has submitted that in course of the proceedings in this matter, the State of Meghalaya petitioner has taken recourse to execution proceedings relating to the same subject matter as is present in these proceedings.
It is Commercial Arbitration Execution Case number 5 of 2024, Lordship.
You filed that, but we have the Learned Counsel has submitted that he may be allowed to bring the details before the court by way of an affidavit. So as to enable this court to consider the entire matter in totality. Mr. Insekon Leonard G has no objection to the preamble, but has submitted that in view of the fact that this matter has travelled for quite some time, no further adjournment will be allowed. This court, being mindful of the manner in which the proceedings has proceeded in this instant case, would however allow the prayer made by the Learned Counsel for the respondent and the said affidavit to be filed within the next date fixed, with an advance copy to the petitioner. However, next month, no further adjournment will be allowed on the next date, even if such affidavit is not filed. So, as prayed for, this is matter on for the hearing on 4th.
Item number 9.
Yes. My long everything. Please.
May it please your lordship. Your lordship, this is an appeal assailing from the impugned judgment and order of conviction dated 14/2/2020 by the learned session judge, Ribari District. So, your lordship, let me come first to the FIR Your Lordship, let me point out first the place of burial. Here, the place of burial actually it contradicts, because in the FIR it's given in Chibra village, but the postmortem is conducted in the Umtranga village. And Your Lordship,
You're referring to page?
yes, Your Lordship, let me come to page number 1. Page number 1 of the FIR, Your Lordship. Here in page number 1, it's in the FIR, it's given in Chibra village, that the place of burial, it happened in the Chibra village, but it actually in the
Burial of what?
postmortem- Yes, Your Lordship.
Okay.
Chibra village. Yes.
It's a murder case.
Yes, murder. But in the post-mortem report, it's actually in Umtranga village. And then Your Lordship, PW1, when you turn to page 18, the statement made by PW1, in the PW1, he did not even know the contents of the FIR, and he even stated that he did not give any statement before the police. And Your Lordship, in the FIR, he mentioned that, according to the FIR on page 1, he mentioned that the appellant itself.
See, Miss, first you have to have the code. You're jumping from one part to the other. Just state the facts. What is the case about?
Okay.
Then, when you come to see, when you criticize the position or the statement of the parties, then you come, see,
Okay.
page wise or witness wise. So if you are confused now, first you go to FIR, then you go to something else.
Yes, Your Lordship.
So tell us, how did the case started and how
Yes.
did it proceed?
Your Lordship, first of all, it started with the FIR filed by PW1, who stated that the appellant accused had murdered her husband. And then, yes.
Okay.
One Srimati Jinarandi Sangma, wife of Arjun Gujwala, who have just 1 week before came to stay in the rented house of Srimati Bahi Sakwa at Yongkuli village, PO Pilangkata, Khanapara, Ribhoi district, Meghalaya, came to my house and informed me that before she was married to one person, namely Dan Tharu Mushahari, the disease, whom she murdered and buried with the help of his family members at Chibra village, because he wanted to marry his own daughter and used to torture her daily. After that incident, she thought that she will surrender herself before the police, but his family member did not allow her to do so. Therefore, she kept quiet regarding the incident, and later on she got married to a person, namely Sri Arjun Gujawala at Chibra. However, today at around 6 p.m., her second husband wanted to kill her with blade. Therefore, she came to my house and told me regarding the incident which she has committed in her past and will repeat the same with her second husband, Arjun Gujawala, if he did not stop to torture her. This is the fact of the case, Your Lordship. But, Your Lordship, in the FIR, the one, he stated that the appellant accused herself, she went to report the incident about to him. But, Your Lordship, according to the statement that he made in the court, he stated that one Srimati, the PW2, she informed the incident to the headman, to PW1. So, Your Lordship, it's contradictory in the statement of the FIR and the statement of PW1. And then, Your Lordship, let me come to PW2. The statement made by PW2. PW2, in her statement, she stated that In para number 2, she stated that she did not even know the name of the accused.
PW2, which?
PW2, page number 21.
What page? Tell us.
Yes. Come to page number 21.
Okay, tell us.
Yes,
What about
she
PW2?
stated that she did not even know the name of the accused. And then she stated that the accused came to her house and told her about the incident. And then she accompanied her to the house of PW1. But in fact, PW1, he stated that she stated the incident. And then, Your Lordship, the PW2, she also stated that while the accused was narrating the story, while the appellant was narrating the story, she narrated in her house in front of her children by the age of 20 years, 21 years, but they were not made witnesses in this case.
Yes.
Then, Your Lordship, let me come to PW3. And then PW3, in his statement, page number 23.
Why they were not made witnesses?
Page number 24.
No, the
Yes.
daughters. These are the daughters of.
Yes, and the
of
daughters,
of the
children by the
accused.
age of 20 and 21 years.
Of the daughters of the appellant.
No, of PW2. Yet, while the accused person telling me about the story in my house, page 21, Your Lordship, the last para. While the accused person telling me about the story in my house, apart from me, my 3 daughters, namely Miss Rustina M. Sangma, aged about 20 years, Miss Blandina Sangma, aged about 21 years, and also my minor daughter, Miss Helena M. Sangma, aged about 7 years, and also my son, Master Lipson Sangma, aged about 13 years. So, Your Lordship, these 2 daughters by the age of 20 and 21 years, they were not made witnesses in this case.
They are not the witness to the crime, isn't it?
No, not the witness, but they are the witness.
See, just tell us after the filing of the FIR what happened, whether the matter was investigated, where the dead body of the deceased was found, and where and how. Just tell us. If you do not tell us, that way we will not understand anything.
Okay. And then, Your Lordship will come to.
After the FIR was registered, then what happened? Just tell us.
There is a conduct of the post-mortem and the inquest.
When did the alleged incident occur?
It occurred in.
See, this was.
30th.
If you read the FIR, you'll find that she had reported the matter on
30th, 1st, 2017.
2017.
Yes.
So that's on 30th January. Now, the informant did not say when she allegedly murdered her husband.
Okay.
But from records or from investigation, what has been found?
It's
What
found that, yes.
What did
Your
DIO,
Lordship, let me come
what did
to
DIO
page
say?
number 15. Page number 15. Yes, that that first para, the prosecution story of the case is that on 30th 1st 2017 at 7 p.m. received telephone information from the headman of Yongkuli village, PO, Khanapara district, Khanapara, Riboy district, Meghalaya, Shri John D. Sangma, to the effect that one lady by the name Srimati General D. Sangma came to him and voluntarily surrendered to him, admitting that she had killed her first husband at the village Chibra in the year 2015
Exactly.
before Durga Puja festival.
Okay.
And then.
So 2015.
Yes, 2015.
Was the body exhumed?
Yes, your.
When? How did it happen? What happened?
Okay, after she has taken in the. Well, let me come to page number 16, Your Lordship. And then after she has taken to custody, she was interrogated thoroughly and she voluntarily confessed her guilt and expressed willingness to lead the police party to recover the dead body of her first husband. Then a prayer was submitted to the Honorable Court for post-mortem, and post-mortem and the inquest also was done for exhuming the body and conducting the post-mortem on the spot. Then the investigating officer of the case had visited the place of occurrence, and then he made a search, and on digging about found the skeleton of a human body being supposedly of the victim, and accordingly held inquest over the skeleton on 1st 2017 at Umtranga in presence of the witnesses. After completion of the whole process, an inquest report was submitted to on 1st 2017. And during the trial, Your Lordship, the prosecution had examined as many as 15 witnesses. And prosecution exhibit also, Your Lordship.
So you tell us, how was the dead body identified?
The dead body has never been identified, Your Lordship.
Not identified?
No, because they did not send for FSL.
Not sent?
No. And Your Lordship, when we come to PW13, the statement made by PW13, the investigating officer, page number 48. Page number 48. Then page number 50, Your Lordship. That number 9. The investigating officer did not pray for DNA examination of the skeleton, as the relatives of the deceased could not be found. Did not even pray for the DNA. And he evenly made the statement, one of the sentence, supposedly.
Page 50?
Yes, page 50.
Para?
Page 50, number 9.
9?
Yes.
Okay.
The investigating officer did not pray for DNA examination of the skeleton, as the relative could not be found. But Your Lordship, actually, he also has children from, so they can go for DNA even for the children also, Your Lordship. But and then and when we come to PW1 also, PW 11 also, Your Lordship, page 44. There is a word supposedly used.
Yeah. Who is this Prabhat Burman? Prabhat Burman. Who is Prabhat Burman?
Prabhat Barman, the co-accused.
Where is he? What happened to him?
Yes, flat.
He has whether he did not turn up for trial, facing trial.
Yeah, he came up, but they cannot found him after that.
What about the judgment? Whether they were tried together or they are tried separately?
Separately.
And whether that person also has been convicted?
Yes, he was convicted.
But then he did not appear before the court.
No, Your Lordship.
The trial was conducted in his absence. So you have to first place the fact before you put all your contention. Please place the fact of the case properly. Court will not be able to appreciate your case. It appears that the dead body was recovered at your instance.
Yes. Yes, Your Lordship, even if recovered at the instance, but they cannot be the dead body was not proof. There are some statement that
may
it
not
may be of the
amount to your
skeleton.
confession. That is definitely that will be that evidence at section 27 probably, isn't it?
Yes.
Anyway, whatever it is, that will come. That protection will be there. But then, whether you have led to the recovery of the dead body or not, that is a vital factor.
Yes, they recovered the dead body, but
And the body was exhumed in front of a magistrate.
yes,
Whether that magistrate was examined by the court.
the magistrate, yes, he was examined by the court.
You see, you have to take us to the fact of the case, then to the evidence, and then thereafter you raise all your contention. Otherwise, it will be difficult for us to get the case.
Miss,
Then
you study the case properly.
Your Lordship, yes, sure. I'll come prepared on another date and
It's a murder case.
murder case.
You have to be prepared. On plea made by Miss Narad Legal Aid Counsel. This is matter after 3 weeks. Mr. Guru, you have to convince us.
My lord.
Identity is not proof. Dead body can be found anywhere.
My lord.
Okay.
Item number 12.